Yeah, there was actually a small glitch. So, as you are aware, for today's discussion, we've actually picked up a number of articles from the Hindu as well as the Indian Express, which becomes extremely important and they are relevant for the UPSC CSE examination, be it your prelims, mains, or for your interview. So, let's actually start the day off with our motivation. So, here it actually says, whoever fights and works hard will surely reap the rewards. So, you know that there is actually no shortcut to your preparation. Okay, so you need to take the stairs. Okay, so nobody will take you through a lift and they will actually help you. There are only people who can actually guide you in your preparation, but there is no shortcut to success. So this is what it is. So you need to fall a number of times but get up and then rework and then finally achieve your goal. Having said this, let us actually look at what are the courses as well as the innovative initiatives that Narayana IAS has actually brought up in order to help you crack this particular coveted examination, that is the UPSC Civil Services. So we have come up with our 1-year prelims come mains integrated course for the 2026 batch, and also we have a 2-year similar course for the 2027 examination, and the total hours of instructions will be around 1000 plus hours, where we will give you curated as well as tailored guidance for prelims, mains, as well as your interview stage of this examination. Moving forward, we actually provide you with general studies as well as the CSAT online course as well as 200 hours of current affairs. Also, we'll actually give you a strategic micro schedule which has been curated by our R&D experts that actually gives you detailed daily study plan so that you're not lost in your preparation. And also we actually give you the privilege of being mentored and as well as coached by the expert faculty who also have similar experience because they've actually reached the interview stage of the civil services. And also we as a team actually provide you regular testing as well as feedback mechanism. Now moving forward, the study materials that we actually offer from our team. One is the Narayana IAS study kit, which actually involves 12 Navigator NCERT books as well as 21 GS Navigator books. And also we actually have categorized the PYQs, which are considered to be the Bible in this particular preparation thematically, and they have been thematically categorized. Okay. Next one, we have our digital resources where 250 plus model answers have been curated by the UPSC interview appeared people or faculties. So this actually makes it very, very possible for them to predict the potential questions and the topics that can appear or reappear in your UPSC examination. And finally is the monthly Navigator magazine, where we've actually completed 1 year, that is 12 editions of the magazine are actually out, and we definitely persuade you to actually read this in order to have a hang of the current affair topics that are linked to the static syllabus as well. Okay. Now, having said this, the topics that have been picked up for today's discussion are from both the Hindu as well as the Indian Express. So let's actually have a look. The first topic is Union Cabinet gives approval for the bills on simultaneous polls. Okay, so there have been two bills. One that is actually talking about framing the laws and regulations of the UTs in line with the Lok Sabha, and the second one talks about making amendments to the constitution itself in order to actually implement this one nation, one election or the simultaneous polls. So here this particular concept of simultaneous elections become very, very important for your UPSC exam, that is both the prelims as well as the mains. Okay, so you need to know what are the advantages of conducting a simultaneous poll. You need to know what are the disadvantages. And here in the 2024 examination, there was a mains question on what are the recommendations by various committees with respect to the simultaneous elections. Okay, so here this particular topic will be discussed in detail, starting from what are simultaneous elections. We'll understand what has been the history of simultaneous elections and what are the advantages, the challenges, the key recommendations of various other committees, what are the global examples and what are the countries across the globe that actually follow this particular practice, and how all this will be discussed here. Moving on, the second topic has been picked up from page number 12 of the Hindu, that is Lok Sabha passes bill in order to amend the Disaster Management Act of 2005. So this particular topic deals with what are the provisions of the Disaster Management Act of 2005, what are all the gaps and the challenges in its provisions, because of which the Disaster Management Amendment Act of 2024 has been passed by the Lok Sabha. So here we'll actually understand this particular concept as it becomes relevant from the disaster management point of view. Moving forward, the third article has been taken from, it's a combination of the Hindu as well as the Indian Express. On Indian Express, you will find it in page number 1. Should the executive have the power to pardon? So here, this is with respect to that of the US President, that is the outgoing US President, Mr. Joe Biden, actually having given the absolute, pardon to his son, to Mr. Hunter Biden. So we'll actually see what are all the provisions under the UN Constitution that actually gives the power or the pardoning power to the executive, that is the president, and how is the pardoning power of the president in India is actually different from that of the United States, because the provisions borrowed from the other constitutions across the globe, as well as how it is different from the other countries, become very, very important. So comparing and contrasting these provisions become very, very important for your UPSC mains in particular. And the final article for the day has been picked up from page number 4 of The Hindu, that is the Controller and Auditor General report flags violation lapses in the enforcement of TN coastal regulation zone notification. So this is nothing but there has been a coastal regulation zone notification of 2011, and there has been a CAG report that actually says that there have been number of lapses as well as violation. A number of projects have actually been given approval, okay, without even getting the major approval from the Ministry of Environment, Forest and Climate Change. So this is what the report actually states. So you will actually be understanding about what are these CRZs and how are they categorized and subcategorized, and how it is important for the exam is what we will be discussing in this particular video. So now let us actually start with our first article, that is Union Cabinet gives approval for bills on simultaneous polls. As I already told you, anything with respect to elections per se is a very, very important topic for your exam, be it the constitutional provisions or be it the constitutional body of the election commission, be it how the election commissioners and the chief election commissioners are appointed, their tenure, the allowance, salaries, whether they are withdrawn from the Consolidated Fund of India and it is on par with whether it is the Supreme Court judge or whether it is the the CJI, etc. All these become whether they are actually allowed to come back, or you can whether they are allowed to serve after their retirement as well. All that becomes very, very important for the examination, and these kind of topics which are dynamic in nature, they become important for your mains examination. Okay, so that is why we've actually taken that up. So here we'll be discussing about the concept of simultaneous elections. Okay, so simultaneous elections will be our topic, that is one nation, one election. And under the prelims examination, this is actually under current events of national and international importance, and for the mains examination, it is GS paper 2, okay, polity and governance, parliament and state legislature. Now let us actually quickly move on to understand what this particular topic is about. So before that, if you see, in 2017, there has been a question. So simultaneous election to the Lok Sabha and to the state assemblies will limit the amount of time and the money spent in electioneering, but it will reduce the accountability of the government. How? So this was actually a question which was asked in 2017, and also in 2024 there was a question on what are the key recommendations of various committees with respect to the simultaneous elections or one nation, one election. So having said this, let us actually move forward and understand why this particular topic is in the news. So recently, 2 bills have actually been approved by the cabinet. What are the bills? One bill is actually seeking to amend the provisions of the constitution in order to facilitate the simultaneous polls. And the second bill is actually talking about aligning the different terms and conditions of the UTs which have a legislative assembly. Who are they? They are actually Delhi, Puducherry as well as Jammu and Kashmir, in order to align with Lok Sabha and the other state assemblies. Okay, so these are the 2 different bills. One bill on the constitutional amendment and next one is aligning the terms with the other states as well as the what to say, with that of the Lok Sabha. So that is what it is. Now let us understand what is this particular concept of simultaneous elections. This is nothing but a practice where we actually hold multiple elections at the same time. What do you mean by multiple elections? You actually conduct the election at national level as well as you conduct election at the state level at the same time in a synchronized manner. So that is what it is. And here what happens is that the voters will actually cast their vote only once. Okay, that is on a single day. They can cast the vote simultaneously for the Lok Sabha as well as their state legislative assembly. And if they are in UT, it is the UT with the legislature. If they are in any of the three UTs of J&K, Delhi as well as Puducherry. Okay, so this actually happens simultaneously or it can happen in a phased manner. So this is what is simultaneous elections. Now moving forward, let us see what has been the history of simultaneous elections in India. Okay. So history of simultaneous elections is that post independence, what happens, this particular concept of simultaneous elections is not new to India at all. So after India actually got its independence in 1947, what happened, the first general elections of 1951 actually was a simultaneous election. So it says it is not new to the country, and post the adoption of the Constitution of India, the first general election to the Lok Sabha and state assemblies were held simultaneously in the year 1951. And this was actually the trend, in fact, till the year 1967. So this actually continued almost till a decade. Okay. So what happened is that the practice of simultaneous election continued in the next three subsequent general elections, that is one in 1957, next is 1962 and then 1967. Okay, then what happened since 1967 is that due to the volatility in the Indian political system or different political parties, there were premature dissolution of either the Lok Sabha or with respect to that of the state legislative assembly. So what happens if my Lok Sabha actually stands dissolved? I cannot actually conduct simultaneous election for all the state assemblies because the Lok Sabha itself is dissolved, right? So that actually became a very big practical problem. So that is what it says. So there were premature dissolution of the state legislative assemblies in the year 1968 as well as 1969. So the cycle of synchronized elections actually got disrupted. Also in 1970, Lok Sabha itself was actually dissolved. So what do you mean by this particular premature dissolution? How does premature dissolution of the Lok Sabha actually take place or the state legislative assemblies take place? That is when a no confidence motion is actually passed, when no confidence motion is passed stating that there is no confidence or where the ruling party actually does not have the majority. So that is when it is, or when they are actually unable to form the government. And in case of state legislative assemblies, it can either be a no confidence motion or it can be stated as the failure of constitutional machinery, where the governor actually suggests the president rule as per Article 356 of the Constitution. So this is what it is. Okay. So this is called as premature dissolution. So since 1967, if you actually see, we have actually let go this practice of simultaneous elections and it could not be maintained, and still we are not being able to realign to the earlier version of the simultaneous polls that we were conducting earlier. So this is the short history of how prevalent was this particular practice of simultaneous election, whether it is actually new right now or whether it has already been in practice. Now let us see some of the benefits of the simultaneous elections. It's very easy, no? If you actually think, common sense, right? So there are two separate, period of time where the Lok Sabha elections is actually taking place as well as the state legislative assembly elections are taking place. But then when they are actually combined, what happens is that huge expenditure is actually going to be saved. So what happens? First one is the cost reduction. So it's going to save a lot of money because there is no need for separate election cycles. At the same time, the government and the people who are involved, that is the ministers and the members of the parliament, that is the Lok Sabha as well as the state legislature, they can actually focus, politicians can actually focus on the long term good governance rather than focusing on the current elections or in order to gain the short term gain. So this is what it is. Next one, it will also result in increased voter turnout because the voters actually come together on a single day in order to vote simultaneously, because they need not have to travel, because many of them are not settled in their own constituency, right? So they need to travel to cast their vote. So voter fatigue is actually here reduced. So voter fatigue is actually reduced. Voter fatigue is reduced, and here voter turnout in turn actually becomes more. The next one, level playing field. Okay, so since the expenditure is actually going to be reduced, what happens is that the smaller parties can have a level playing field along with that of the larger parties because of the total reduced expenses, and also efficient use of security forces. Okay, so here the security forces, that is the central armed forces, right? They actually come for providing security during this particular elections, right? So what happens is that when it is happening at one particular time, there will be more efficient use or efficient utilization or deployment of these particular security forces, and they can also be efficiently deployed for other services at the some other time. So this is what it is actually saying. But however, this particular simultaneous elections actually have a lot of challenges. First one is the synchronization challenges. Okay, what do you mean by synchronization challenges? Actually, conducting the Lok Sabha elections and the state legislative assemblies can be a huge problem because India is a huge democracy. So it is going to be very, very difficult to actually conduct the elections at the same time. The next one is constitutional and federalism issues. Okay, so there has to be a lot of constitutional changes that actually have to be brought in. Okay, that is Article 83 of the Indian Constitution. It actually fixes the term, that is a 5-year term for the functioning of the Lok Sabha. So that actually has to change, because in case that Lok Sabha is actually dissolved, what happens is that you cannot conduct once in 5 years, right? So the period actually has to be changed, and then Article 84 actually has to be changed. Similarly, for the state legislative assemblies, other articles of the constitution, and then Article 324A of the constitution actually has to be changed. So all this is a concern. So when all that is actually changed, that will challenge the very basic or the federal nature of the Indian political system. Next one, impact on voter behavior. So when it is happening at the same time, it is boon as well as the bane. Okay, so first one, it reduces the fatigue, it's advantage. But then what happens? They are actually confused about what are all the mandate, or what are all the election manifesto or the promises that the state legislative assembly members or the politicians or the national parties have actually given. So confusion over national and the state issues, and this actually blurs the distinctiveness of the state level politics. Next one, there is going to be impact on the regional parties, because generally what happens when it is when the national and the state elections are actually taking place together, what happens is that the people actually start favoring the larger national parties against the regional parties. The next one, accountability concerns. Okay, what do you mean by accountability concerns? See, right now there is actually no provision in the constitution in order to conduct the simultaneous elections. Okay, but so what happens here? The term is fixed for 5 years. In case if there is a premature dissolution, then what can actually be done constitutionally. Here what happens is that in case if you actually decide to conduct simultaneous elections, there is for example, if a particular time is or a day is actually fixed, or a particular year is actually fixed, for example 2024, what happens is that this actually reduces the scope of threat to call off. What do you mean by that? It is actually nothing but dissolution of the Lok Sabha or the state legislative assemblies won't happen at all. That is, so then what happens? They actually know, anyways, this particular year we are going to contest the next elections. So until then, they won't be accountable to what they are doing. So no threat of recall. So government accountability is lost, and that actually leads to a lot of autocratic tendencies. Okay. So these are few of the challenges of the simultaneous elections. Now, what are the changes required in the current constitutional framework in order to hold the simultaneous elections? Currently, it is not possible to actually conduct the simultaneous elections. If we want to conduct, what happens is that this particular Article 83, which actually specifies a fixed term for the Lok Sabha and the state legislative assembly, has to change. Next one, Article 85. This is nothing but introduce. This actually gives the guidelines. It actually empowers the president to issue the guidelines for the dissolution of the Lok Sabha to prevent arbitrary actions. Okay, so this actually has to be changed. And the next one is Article 172. So like 83, this 172 also has fixed the term of the state legislative assembly. And next one is Article 174. This is meant to include clear guidelines for the dissolution of state legislative assemblies. So all these provisions actually have to be changed from the current constitution, which again will actually question the federal nature of the constitution. Okay. Now, moving forward, what have been the recommendations of various committees? This becomes very, very important because this question has come in the 2024 mains examination and also has been covered by the magazine. Okay, that is a Navigator magazine. So if you see the first annual report of the Election Commission of India 1983, so this actually says, so what so the first annual report of the elections of India in 1983, it actually said yes, simultaneous elections are actually possible. Why? And why it is actually important to conduct simultaneous elections for Lok Sabha and state assemblies? Because of the cost savings. There is efficient voter roll updates, that is simultaneous electoral roll revisions are actually made, so cost savings are actually done. Next is there is minimized disruption, okay, because you are actually in deploying the personnel, there is minimum disruption, there is not much confusion. Next one, there is enhanced governance, that is there is stable administrative setup. No sidelining of regular government functions. You don't postpone anything per se like a number of times, so that there is actually only one particular period which is fixed for the simultaneous election. So this is what the Election Commission of India report had actually said. Moving forward, there was the 170th report of Law Commission of India. This also recommended the simultaneous election. Next, what happened? The 79th report of the Parliamentary Standing Committee on Personnel, Public Grievances and Law and Justice. This also had actually said that simultaneous elections can be conducted and it can be seen as a means to achieve long-term good governance, because politicians are not going to focus on the short-term gains. And finally, the recent Ramnath Kovind committee, this was actually headed by a previous, ex-president, Mr. Ramnath Kovind. They actually said you can actually conduct these simultaneous elections, but simultaneous elections can be for the Lok Sabha, the state legislative assembly, the municipalities as well as the panchayats. However, the cabinet actually said that we won't be able to include the local bodies, because then again you need a constitutional amendment of Article 324A, okay, plus you need ratification by half of the states. Your homework is to know what are the situations where you need ratification of states and what is the procedure, and also you need to know what do you mean by premature dissolution of Lok Sabha, who can do it, what is of the state legislative assembly and who can do it, whether it is the president or the governor. All these things you need to know. Okay, now moving forward, let us actually see what are the global practices. It is actually across different countries like South Africa, Sweden, Belgium. All these actually practice the simultaneous elections. The first one, South Africa, where the elections to the National Assembly, provincial legislature and municipal councils actually happen in a 5-year cycle. And the electoral system is based on party list proportional representation. What do you mean by this? Here, The parties are represented based on the proportion of support or the voters it actually has. So this is what it is. Next one is actually Sweden. Here the county councils and the municipal councils, actually the elections to these county councils and municipal councils are done along with the general elections. Okay. So general elections is what? The Riksdag. What do you mean by Riksdag? It is the national, it's like the parliament. Okay. So it is the National Assembly or the national legislature. Next one is municipal assemblies. Here what happens, election to this is actually happening on second Sunday of September. This and all is not important. It's just the example of countries that actually follow. Next one is Belgium. Here people can vote in 5 different kinds of elections. What do you mean by 5 different kinds of elections? There is a national election. There is regional election. Also, there is community election depending upon the culture, the language, etc. And there is also local election like municipality, panchayats and all those things. Okay. So, these are the different types of elections that actually take place in Belgium. And also, the fifth one is the European election, because Belgium is a part of the European Union, and so it is actually part of European Union election also. So here elections to the federal parliament is done every 5 years, and this coincides with the European Union elections. Okay. So these are few examples, and moving forward, what are the ways that are proposed? Let us actually see over here. So there have been proposed models for implementing simultaneous elections in India. First is, if it is not possible to conduct the entire election in a diverse democracy like India, what we can do, we can conduct it in phased manner. In the first phase, it can be in sync with the Lok Sabha elections. Okay. So phase 1 can be in sync with the Lok Sabha elections, and in phase 2 that can be somewhere midway in the term of the Lok Sabha. That is, here what happens is that elections take place once in every 5 years, right? So it can be conducted in 2.5 years. Okay, that is once the entire electoral cycles of the Lok Sabha and all the state assemblies are synchronized. So this can be done, is what they are saying. Now moving forward, avoiding the premature dissolution. The Election Commission has made the following recommendations. So premature resolutions you cannot avoid completely, right? Because it does not hold the government accountable, because they will know anyways we are going to compete in the next election which is scheduled in this particular year. So till then there is no premature dissolution. So how the government will be accountable for its activities? So the Election Commission has actually come up with certain recommendations on Lok Sabha as well as for the Lok Sabha as well as the State Legislative Assembly. So for the Lok Sabha, premature dissolution can actually be done. How the dissolution happens? By no confidence motion. So when you are passing no confidence motion, you should also pass a confidence motion where you are aware, or where you actually come up with the name of the next government that is actually going to be set up and who shall be the Prime Minister. So any no confidence motion should also include a confidence motion, and there has to be a name of an individual as the future Prime Minister. And the dissolution cannot be avoided. If the dissolution cannot be avoided, so when the dissolution cannot be avoided, what happens depends on the time frame. For example, if the Lok Sabha has actually only functioned 2 years and it has 3 more years to complete. So this period, the remainder of the period, if it is actually short, or for you can say the Lok Sabha has actually completed 4 years, it has only 1 year remaining. So if the remainder of the term is short, the president can administer the country with a council of ministers who is appointed by him until the next house is constituted. In case if it is actually long over here, that is if there are 3 more years, what happens is that fresh elections may be held. So this is these are the recommendations given. So this is in case of Lok Sabha. If you move to the legislative assemblies, the same thing. In case any no confidence motion is actually passed, it has to have a confidence motion also for an alternative government. And if dissolved prematurely, what happens? The governor can actually administer the state with the help of the council of ministers that the governor has appointed, or he can call for the president's rule, actually stating the failure of constitutional machinery. So this is what it says. And now moving forward, the Parliamentary Standing Committee, it recommended by-elections. Okay. So by-elections are what? For example, when a by-election is done, when a particular seat is actually, it falls vacant. Okay. Why it falls vacant? Due to number of reasons. Maybe because of resignation of the person, or it can be because of death. Okay. And it can be because of defection. Okay, because of all these reasons, or it can also be because of removal, etc. So do you understand? So that time by election actually has to be conducted. So what are all, or you can say what are all the number of seats that are actually vacant during a year? The by elections to all the seats must be conducted together and not separately. And finally, we have the Law Commission recommendations. It actually says that the elections of legislative assemblies whose term is going to be, ending in 6 months after the general elections to Lok Sabha can be clubbed together. So these are the recommendations that have been given by various committees. Okay, so that particular topic of simultaneous elections actually is important. So these topics actually have many of the micro topics inside. Okay, so you need to know about election commission, why the election commission has actually come forward with the recommendation in terms of dissolution. What is the period of dissolution? If it is shorter, what it is. If it is longer, what the election commission has actually stated. And also what is the concept of this particular simultaneous elections, how it is actually going to reduce the burden on the exchequer. All that becomes very, very important for your exam. Now moving forward, let us quickly go to the second article, that is the Lok Sabha passes bill to amend the Disaster Management Act. So as such, GS paper 3, the disaster management actually becomes very, very important. And any kind of these acts, the bills, like for example, you had this what to say, the BNS. The BNS is replacing the IPC, the CRPC, and the Indian Evidence Act, right? So all that becomes important, and how are the provisions different, and how it is going to make the governance of the country much more easier and different according to the current social norms and conditions, that becomes very important. So here we will actually be discussing about this Disaster Management Act of 2025, what it actually aimed to establish, and what were the gaps and the challenges associated with it. Okay, and also we'll be looking at this particular bill 2024 that has been passed in the Lok Sabha. So here the Disaster Management Act of 2005, the Disaster Management Amendment Bill of 2024 becomes important as it's part of current events of national and international importance, and for the mains exam it is important from GS paper 3, disaster management, and also GS paper 2, governance. Okay, now moving forward, let us actually see. In 2020, there has been a question that is discussed the recent measures initiated in disaster management by the government of India, departing from the earlier reactive approach. So what has been earlier and currently what have been the different methods that the government of India has actually come forward. So the disaster management bill has been passed in Lok Sabha, and this actually aims to amend the Disaster Management Act of 2005. Let's quickly go through what is the Disaster Management Act of 2005. This is nothing but this act actually came to existence in order for ensuring effective disaster management via institutional mechanisms, that is by actually establishing a national disaster management authority, a state disaster management authority, a district disaster management authority, and also a national disaster response force, etc. So to ensure disaster management through the institutional mechanisms, plus taking all kind of measures in order to prevent, in order to mitigate, as well as to give response to any kind of disasters that actually happen in the country. So what is the institutional framework? It is actually set up under this act. There was this National Disaster Management Authority that is headed by the Prime Minister. We have the State Disaster Management Authority led by the Chief Ministers. We have the District Disaster Management Authorities overseen by collectors and district magistrates or deputy commissioners, and followed by that we have National Institute of Disaster Management that actually focuses on capacity building for our enhanced approach and preparedness. And finally, National Disaster Response Force, very, very important, which handles all the disaster response planning as well as other financial matters. Okay, so this is the Disaster Management Act. Under these are all actually provided. Next one, the Disaster Management Act actually entails a number of plans and specific funds. Okay, so what are the plans? Here the ministers and the departments must actually align the plans with respect to that of the national plan. Okay, so the ministries and the departments must align the plans with the national plan. Second, with respect to funds, it actually establishes the National Disaster Mitigation Fund for disaster management at various levels. Next one, what is the role of the local authority? This actually emphasizes the importance of local bodies in disaster management. Okay, so what is the role of the local bodies here? This is where you'll actually integrate it with which actually enhances the relevance of 73rd and 74th Constitutional Amendment Act. So, because of this, where Panchayati Raj as well as the municipalities actually come here. So, what is their role in disaster management? So, it emphasizes the importance of these local bodies. Next one, the legal institutional framework. This actually details the vertical and horizontal hierarchy of disaster management. Excuse me, I'm sorry for that. Yeah. So now, this is what it's actually talking about, the vertical as well as the horizontal hierarchy of disaster management. So, this is the institutional framework. So, you have the central government. Do you understand? So, under the central government, you have the National Disaster Management Authority. Okay. Secondly, after this, you actually have the state government, and under the state government, you have the State Disaster Management Authority. Okay. Then you have the district administration, which is nothing but your panchayats as well as the municipalities, and then you have the district disaster management authority. Do you understand? So, if you actually see, the nodal ministry over here is actually the Ministry of Home Affairs. So, this is the nodal ministry, and under that you actually have this Institute of Disaster Management, and you have National Disaster Management, a National Disaster Response Force. And then if you actually see under NDMA, you have the National Executive Committee Chair, and then you have the State Executive Committee Chair, and also you have the DMD as well as the DDMA. So, this is the vertical and the horizontal institutional framework that has been set up for disaster management in India under the national level as well as the state level. Now, moving forward, let us actually see what have been the gaps that have been observed in the DM Act of 2005. First, the Act actually did not have the detailed provisions for urban specific disaster management. It actually had general guidelines, but urban specific disaster management was actually not there. So, the coordination and management actually was not there. Next one is response capacity. This actually established only a National Disaster Response Force, and no provision was given for SDRF. Next is the statutory recognition. So, this particular act did not give statutory recommendation to critical committees which are involved in this disaster management. What are they? They are the National Crisis Management Committee as well as the High Level Committee. These were not there, but currently this particular bill that has been passed, that actually gives statutory status to these critical committees, that is National Crisis Management Committee and High Level Committee. Now, moving forward, also there have been gaps in the regulatory framework, that is the power to make regulations. They were not clearly defined. So, who has the power to make the regulations? What are the regulations? They were not clearly defined, and because of which there were a lot of delays and there were inefficiencies in the execution of the disaster management strategies. Also, this particular rule was actually not updated to the evolving hazards, particularly in the urban areas. There are a lot of hazards, right? Technological hazards are also there. There are also climate specific hazards because of this increased menace of climate change and pollution. So, here it is not updated as per the evolving risks, is what the article actually says. So, what are the provisions in the new bill? First one, there has been establishment of the urban disaster management authorities. So here, if you see the formation, the state governments actually constitute this particular urban disaster management authorities. We saw, right, there has not been specific plan for the urban areas. Here in the new bill, there has been urban disaster management authorities which will be set up by the state governments. And also what happens is that these will be for the state capitals and the cities with municipality or municipal corporations. Moving on, the structure, the chairman will be the municipal commissioner and the vice chairman will be the district collector. What will be the function? Preparing and implementing all the disaster management plans for the urban areas. Next, there is state disaster response force. That is nothing but the formation. This actually empowers the state government to establish the state, that is the bill actually gives the power to the state governments in order to establish the state disaster response force. What is the function? The state governments will define the functions and the terms of service of these particular members who are involved in the state disaster response force. Okay. Now moving forward, there have been the statutory status that have been given for this committee, that is the National Crisis Management Committee, where the cabinet secretary is going to be the chairperson and the function will be to handle the major disasters, right? So that is one with serious national ramifications. Next, again, the high level committee has also been given the statutory status. The function is to provide the financial assistance to the state governments, and it approves the assistance from the National Disaster Mitigation Fund, and the chair is whoever is the minister who is actually in charge of disaster management will be the chair of this particular high level committee. And also, how are the appointments to the NDMA authority? The NDMA, that is, the NDMA can specify the number and the category of its officers and the employees and can appoint the experts and consultants with prior approval from the central government. Okay, so this is what are the provisions of this particular new bill. So overall, if you see the analysis, the urban focus that was actually lacking or lagging in the earlier bill or the earlier act, that is Disaster Management Act of 2005, that has been rectified in this particular bill. Next one, there is enhanced response capacity because the statutory status have been given, establishment of a state disaster response force was given, and also we actually saw, right, that is statutory recognition has actually been given here. Now moving on, the Disaster Management Bill of 2024, this actually enhances the capabilities with respect to that of disaster management for India. So this is actually going to address various issues like urban vulnerabilities. It's going to, increase or empower the local responses, and also it gives a proper or specific or clarified guidelines for the institutional roles. And also, continuous evolving evaluation and adaptation of these frameworks are essential in order to address the challenges, in order to ensure that we are effective in our disaster resilience and response. So in case if this actually comes, like how has India enhanced its disaster response with respect to that of its legal framework when compared to the previous act? How is it actually done? If the question is asked in that sense, then you need to talk about the Disaster Management Act of 2005, how it actually failed. I mean, not fail exactly, what are the gaps that it actually faced, and how this particular bill of 2024 has enhanced it is what you need to know, and you need to come up with this particular conclusion. Now let us quickly move to the next and a very, very simple article, that is, should the executive have the power to pardon? So here we'll actually discuss about the power of the president to pardon in the United States versus with respect to that of India. So few days back also you actually saw, right, there was martial law in South Korea. So we need to know what is martial law, and in case of martial law, what is actually the powers of the president in India with respect to that of South Korea. For that, you need to know what is martial law, how it is different from that of the national emergency, and is martial law different from that of the military law. All these things become very, very important for your examination. So similarly, anything that is in news from the developing or the developed world, and how it can be compared with that of the constitutional provisions of the Indian constitution becomes very, very important. So should the executive have the power to pardon? So here The president's power to pardon in the US and India, as well as Indian constitution and provisions borrowed, become important, and these actually are important from polity perspective for the prelims examination, and for mains it can be under GS paper 2, comparison of the Indian constitutional scheme with that of the other countries. Okay, so this is what it is. Let's quickly move to the PYQ asked in 2018. India and US are two big democracies. Now, talk about two basic tenets on which the political systems of the two are actually based. Okay, so we need to discuss the two important tenets. Now, moving forward, why this particular article is in the news? Because the US president, that is the outgoing US president, Mr. Biden, has actually granted a full and unconditional pardon to his own son, that is to Hunter Biden. And this person is actually facing sentences in two cases. One is involving tax evasion. So one is tax evasion, and next is making false statements about drug use while purchasing a gun. So this is actually not important. Here what is important is pardoning power of the President of United States is what is important, and how it is different from that of India. So let's quickly see what is the pardoning power of the President of United States. So this is actually governed by Article 2, okay, that is Section 2 Clause 1 of the United States Constitution, which actually gives absolute power to the president to grant pardons except in cases of impeachment. Okay, so there is absolute power to pardon, and in case of the federal criminal offenses. Okay, so this is what the president actually has. So here this is actually started back during the period of English history itself, right from the 7th century. So here itself the presidential pardon and the powers actually had started. Next, the office of the pardon attorney, which is nothing but this office of the pardon attorney, part of the Department of Justice. This actually aids the president to pardon petitions, I mean thousands of petitions that actually come to him annually. So how is the process? Initially, what happens is that the review and the background check of this particular federal crime is actually done by a federal Bureau of Investigation, that is the FBI, just like the CBI. A background check is done, and then the recommendation is given to the president. But whatever recommendation is given to the president is non-binding in nature, and the decision of the president whether to pardon or not stands final. Okay, so this is what is the pardoning power of the President of United States. So here the president, that is under Article 2 of the US Constitution, the president's pardon power is limited to offenses against the United States. Okay, what do you mean by offenses against the United States is that, or any offenses against the federal law, and this federal law, any offenses against federal law which actually applies to state as well, applies to states as well. So in this case is only what, see, we have the central list, the state list, right, and the concurrent list. So similarly, what happens, there is a federal law that actually applies to the entire country, but there are state laws itself. Okay, that is why it's the United States of America. So that is what is United States. Okay, so here any federal law that actually applies to the states as well, in that the president actually has the pardon power, but he cannot pardon the crimes that are violations of the state law, and also cannot grant pardon in cases that involve impeachment. And also for the president to pardon, what happens is that crime must be committed first, right? So crime must be first committed, and once a federal crime is actually committed, the president can exercise the power to pardon at any stage. At any stage he can pardon. That is, even before the charges are filed, he can pardon, or during the progression, or when the case is going to be filed and during the process, then also he can pardon, or even after conviction, or even after sentencing. So this is how the pardoning power of the President of the United States actually works. Now let's move to the most important part of this particular topic. How are the pardoning power of the President of India actually governed? That is as per Article 72 of the Constitution, where the President is actually empowered to grant pardon, to actually reprieve, respite or remission of punishment, or to suspend, remute or commute the sentence of any person convicted of any offense. So first let us actually understand these basic terms. So what do you mean by pardon? Pardon is nothing but you are absolved or you are acquitted from your mistake. Now, once the president actually pardons you, that means you do not hold any guilt of any kind of charges. Okay, so you are completely free. So that is called as pardoning. The second one is commute. Commute is what? It is actually reducing the nature of the punishment. Okay, what do you mean by reducing? That is reducing the type of punishment. That is, if it was a rigorous imprisonment, it is converted to simple imprisonment. So that is commute. The next one is remission. What do you mean by remission? Here, the period of particular, the sentence or period of the particular conviction is actually reduced. That is, rigorous imprisonment of 30 years will be reduced to rigorous imprisonment of 20 years. Next one is reprieve. Reprieve is nothing but you are actually delaying the execution of a particular person's sentence. Okay, so delaying, so that you are actually giving him or her time to prove innocence, so delaying the execution. And finally you have respite. Here also the nature of this particular sentence is actually reduced based on certain criteria like pregnancy, like old age, etc. So these are the different terms. Okay, so pardon, reprieve, respite, remission of punishment, or can remit or commute the sentence of any person. So what are all the offences in cases whether the punishment or sentence is actually imposed by a court martial? So in that case, the president can do the following above. And then in case where the punishment or the sentence is for an offence against anything related to the union's executive power, and in all cases where the sentence is a death sentence. So in all these cases, the president can actually carry out or he can implement his particular power to pardon. Next one, we will actually see what have been the observations of the Supreme Court with respect to the pardoning power of the president. So in Maru Ram versus Union of India 1980, the Supreme Court actually held that president cannot grant a pardon independently. Okay, so he actually has to act on the advice of the Union Council of Ministers, and also the court will actually review this particular exercise of the pardon of the president under Article 72 only in rare cases where they actually feel that the president's pardon was actually irrelevant, it was irrational, discriminatory, or it is actually unconstitutional or malified. Next one, the similar thing is actually provided to the governor also. Okay, under Article 161, where the governor can actually grant pardon, reprieve, respite, or remission of punishment, or he can suspend, remit, or commute the sentence, or any kind of in cases of offences against any law which is actually related to a matter to which the executive power of the state extends. Okay, so this is actually the power difference. That is the pardoning power, how it is actually different from that of president and the governor is what we will actually see here. So in case of death sentence, the president can pardon the death sentence, but the governor cannot pardon death sentences. If the offence or if the punishment has been given by a court martial, then the president can grant pardon in case of court martial. If you see here, the governor cannot grant pardon in cases of court martial. And if you see the jurisdiction, he exercises the judicial powers for punishment under union law, and the governor in he or she also exercises the judicial powers for punishment under the state law. So the government cannot do in case of union law. So this is what it is. So finally, actually we are actually moving on to the last topic of discussion, that is CAG report flags violation or lapses in the enforcement of the CRZ notifications. So let us actually see what this article talks about. So here very important is just to understand this particular concept of coastal regulation zones along with sustainable development, and it's important under environment for the prelims examination and for the mains under GS paper 3, environmental pollution and degradation, conservation as well as development. And if you actually see, there has been a previous year question on eco-sensitive zone. So you can also have question on coastal regulation zone, right? And which is the ministry that actually formulates these regulations? When was it, recently notified? All those things can be asked in your examination. So now let us actually see. There was recently a Controller and Auditor General report, and this was actually, it has identified that there have been significant lapses, there have been significant delays as well as violations that have been carried out by the authorities of Tamil Nadu. That is, they did not abide by the Coastal Regulation Zone 2011 notification. So this is what the report has actually identified. So what the report has actually identified is that the Tamil Nadu Coastal Zone Management Authority, they have delegated their role to all the local authorities as well as the district coastal zone management authorities. Okay, and this violated, they violated the CRZ, that is Coastal Regulation Zone notification, that was released in 2011. How do they call it as violation was that a number of projects, that is even the sewage disposal or discharge projects, were actually given NOC by the pollution, Tamil Nadu Pollution Control Board, that is the State Pollution Control Board. And also so many projects were approved, around 114 out of 175 projects. These numbers are not important, I am just telling you. These many number of projects have been approved by the state authorities itself, that is by this coastal zone management authority itself, without actually forwarding it to the Ministry of Environment, Forest and Climate Change. So this has also disrupted the process, right? So this has what these are all the observations that have been given by the Controller and Auditor General report. Now let us get into the topic on understanding what are coastal regulation zones. So these are areas along India's coastline. Okay, so if this actually happens to be India's coastline, so what these are the areas along India's coastline where the development activities like any kind of infrastructure as well as construction or even conservation projects are regulated in order to protect the fragile ecosystem or the coastal or the marine ecosystems. At the same time, you actually see to that there is sustainable development as well. So this is what are the coastal regulation zones. These regulations are issued under the Environment Protection Act of 1986, very, very important. And the rules are notified in the Coastal Regulation Zone Notification 2019, and this actually supersedes the earlier one, that was the CRZ notification 2011. Now moving forward, if you actually see over here, this is supposed to be the sea. This is your sea region. And if you see the red lines over here, this actually marks, if you see the red lines over here, this actually marks the high tide zone. So when the sea is on high tides, this is the high tide zone. It can actually extend till here. And then if you see the blue color line over here, this is the low tide zone. Okay, and then if you see this blue color dotted lines, okay, so this is nothing but this is the 50-meter coastal regulation zone line. So here it is further subdivided, okay, CRZ1A, CRZ3, depending on how important it is and what kind of development zone it is, what kind of projects are allowed there, what are not, all that is there. Okay, so this is what it is, this blue color dotted. Then if you see the green color dotted lines over here, these lines over here, Okay, these lines. So these are nothing but the 200-meter CRZ line. And finally, the pink ones are actually the 500-meter CRZ lines. And then this entire red region, this is actually nothing but the 50-meter mangrove buffer. So these mangroves which actually protect, okay, this particular area from any kind of storms, from any kind of tsunamis as well as other catastrophe. So that is categorized under CRZ 1A. And finally, this is the region, this yellow region, this is called as the CRZ3 zone, where it is also called as the NDZ zone, where no development is actually allowed. Okay, so this is how the CRZ classification in India is done, and it is also certain regions are actually done based on the population density. That will be further, will be it is it is subcategorized under CRZ3. Okay, so let's quickly go through. Yeah. So CRZ classification in India, first one CRZ1 is there, that is classified as CRZ1A as well as 1B. So 1 is nothing but ecologically sensitive areas. So these are very critical and they are classified into 1A as well as 1B. 1A is nothing but ecologically sensitive zones, which are the mangroves, the corals, the sand dunes. Then you have the turtle nesting grounds, you have the national parks, the sanctuaries, etc. They are part of CRZ1A. Okay, and here these actually act as natural barriers against the storms and support the biodiversity, and these are declared as a no development zone, except for only the environmental conservation projects can actually take place over here. Next one is CRZ1B. This is nothing but the intertidal zone, that is the land which is present between the high tide and the low tide. Here the development is allowed, but again only projects which are requiring the waterfront access, such as the ports, the harbors as well as the fisheries. So this is nothing but the CRZ1. Next is, those are ecologically very sensitive areas. Next is CRZ2, developed land areas. This is actually located within the municipal limits as well as the other urbanized regions. Okay, so here more than 50% of the area is built up with lot of infrastructure like roads, drainage, we have the sewerage system, etc. And the allowed activities actually include only reconstruction and repair of authorized structures, and no new large scale industries are allowed here, and these are not classified as NDZs, whereas CRZ1 they were considered as no development zones. Okay, but activities must comply with urban planning laws as well as environmental safeguards. Now moving forward, we have CRZ3. These are relatively undisturbed areas. Okay, so they are rural or they are relatively less developed areas. This is further subclassified as CR3A as well as CR3B. So CR3A is nothing but densely populated areas, and as per 2011 census, whichever area has a density or a population density of around 2,161 persons per square kilometer, these are actually categorized as CR3A, and land up to 50 meters from the high tide line is designated as a no development zone. Also CR3B, these are less populated areas, less than these many persons per square kilometer, and land up to 200 meters from the high tide zone, that is actually considered to be the no development area. Now moving forward, CRZ4, these are water areas. So this actually covers the water. I'm sorry for this. So this actually covers the water area as well as the seabeds, and again it is divided into A and B. A actually includes water and the seabed areas between the low tide line up to 12 nautical miles seaward, and fishing is allowed here, but no dumping of hazardous substances and plastic. The next one, that is CRZ4B, covers the water and seabed areas where rivers, creeks, backwaters and lagoons are there, and activities are regulated in order to minimize the ecological damage. Okay, so this is what it is. And final is the critical vulnerable coastal areas. So this actually involves the Sundarbans, the Gulf of Cambay, the Vembanad Lake, as well as Gulf of Mannar, and these are actually managed with the involvement of the local communities in order to ensure sustainable living. Okay, so this is what it is. Now moving forward, let us quickly solve a mains practice question, okay, based on the discussion that we actually had today. So examine the implications of conducting simultaneous elections to the Lok Sabha and the state assemblies in India and discuss the potential challenges and benefits. Here you know, right? Simultaneous elections, what do you mean by that is what we'll discuss here in the introduction. And in the body, you'll be discussing about the benefits like cost reduction, the voter turnout will be actually enhanced, efficient governance or good governance will be there, and challenges are synchronization issues as well as accountability concerns, and impact on the regional parties will actually be more. And also, we'll be discussing about the committee recommendations, like what did the election commission, the law commission actually say, and the parliamentary standing committee report shall be discussed over here. And finally, now let us actually solve the prelims practice questions. So hope you guys would have actually solved these particular this question on the website, okay, as it was actually discussed yesterday with you guys. So now let us actually see what it is. Consider the following statements with respect to ILO. It is a specialized agency of the United Nations and it's headquartered in Switzerland, Geneva. Yes, this is the correct option. Okay, so I hope you guys have actually solved it in our website in order to have a better experience of the testing atmosphere, and you'll also be given immediate feedback. Okay, that is how you have the explanation over there, and you'll be marked right or wrong depending on the options you actually choose. Next one, so this is actually correct, and India has ratified all 8 of the ILO fundamental conventions, including no, India has actually not ratified 2 conventions that include the Freedom of Association Convention as well as Right to Organize and Collective Bargaining Convention 1949. Okay, so only the first statement is correct, the second one is not correct. So whether India is a signatory, India has ratified, why it has not ratified, what are the conventions it hasn't ratified, very important for your prelims examination. Moving on to the second question, malaria is caused by, it is caused by female Anopheles mosquito. No, right? So, malaria is actually a vector-borne disease and the vector is nothing but the mosquito. Here, the mosquito is actually being affected by this particular, parasite. I mean, it is actually affected by what? It is affected by plasmodium over here. So, plasmodium is what actually causes malaria. So, here C is actually your answer. Now moving forward, the next question is hemophilia. So what is hemophilia is something you need to know, whether it is by the chromosomal aberrations or any kind of aberration in the X chromosome or the Y chromosome, whether males are affected more, the females are more. All these things you need to know. Hemophilia A is the most common form of hemophilia caused by deficiency of clotting factor. Yes, it is the most common caused by clotting factor. Hemophilia is inherited through X chromosomes that affects only males. No, females can also be carriers. So this is wrong. And gene therapy offers the potential for a one-time cure. Yes, gene therapy can actually be there in order to correct any kind of the chromosomal aberration as well as gene alteration. So this is correct. So 1 and 3 are actually correct. So here the correct answer will be option C. Now moving forward, the questions for the day, it talks about the Disaster Management Amendment Bill. So what the state governments can do and the NDMA can actually make regulations. So all these things you need to mark your answers in your comment section, okay, and also you need to solve these MCQs so that they will be taken up by me tomorrow. So moving forward, again there is a question on the pardoning power. There is again a question on the pardoning power of the President of India, and moving forward here you actually have a question on the no development zones under the coastal regulation zone rules in India. So all these things we'll actually explain and we'll actually get it clarified tomorrow. By then, based on our discussion, I would actually request you to solve it on the website. So for now, we are actually done with our daily news analysis. I hope you actually found it very interesting and informative. So for further such live videos, please do like, share and subscribe to Narayana IAS Academy YouTube channel. Thank you.